Friends, today I am going to discuss company law. Second, the topic is operation and mismanagement. So, what do you mean by operation and what is meant by mismanagement? So, in company law, operation refers to unfair conduct against members that violates principles of fair treatment. Whereas mismanagement relates to actions harmful to the interest of public, the company or shareholders, often arising from changes in the management. The company law, primarily under section 241 to 246 of the Companies Act 2013, provides remedies for these issues, allowing members to file petition in tribunals such as NCLT for relief, such as regulating matters, removing directors, or purchasing shares to protect minor rights. NCLT stands for National Company Law Tribunal. So, when the members have any issue, they can file petition in tribunal NCLT for relief, such as regulating matters, ensure proper corporate governance. Now, what is the definition of operation? The improper exercise of power by majority shareholders or directors against minority members deviating from standards of fair conduct. It is not merely unwise management but rather harsh and illegal. Examples of operations: depriving of rights when they are deprived of their rights. Abuse of power when the company makes abuse of power, making decisions that result in unfair discrimination against members or increasing capital just to gain control. It should involve a lack of honesty or fair dealing in relation to ownership rights. We can say the company is oppressing the minority members when there is a lack of honesty or not fair dealing, but not just a lack of trust. Now coming to mismanagement, inefficient, dishonest or prejudicial conduct that is harmful to the company or public interest is called mismanagement. Key elements of mismanagement: actions contrary to the objective of the company. When the company's action is contrary, in contrast to the objectives of the company, purpose is lost. Illegal boards, serious conflicts of interest, or embezzlement of funds. Example: inefficient management, misuse of assets, non-compliance with the law, or action that may lead to litigation against the company. Section 241 says application to tribunal for relief in case of operation. If any member of the company is affected due to operation, then he can apply for the tribunal. It says section under 241. Who can apply? A member or members of a company or the central government. Basis of application: activities of the company that are contrary to public interest or the interest of the company or its members. A significant change in management or control that is not in the interest of members, creditors, debenture holders. Second, fraud, misconduct, negligence or betrayal by management. Third is the business is not based on proper commercial principles or is being operated for fraudulent purposes. Section 242 says powers of the tribunal. When it applies, if the NCLT upon an application under section 241 finds operation or prejudice, and members would suffer unfairly from winding up. Orders that can be passed by NCLT to put an end to oppressive conduct, the tribunal may issue the following orders. Number one, regulation of the company's affair in the future. Okay. Purchase of shares by other members of the company, which may also include a reduction of capital. Restriction on the transfer or allotment of shares. NCLT may restrict transfer or allotment of shares. Removal of managing director. Some directors, managing director may be removed. If they are found guilty, they may be removed. Managers or any director from the office. Appointment of directors. After cancelling the appointments of managers, existing managers, new appointment of directors can be done by NCLT, cancelling or modifying agreements. Other orders deemed appropriate to resolve the matter. Whatever NCLT thinks better, the NCLT will decide. Now, major powers of tribunal. What are the major powers of the tribunal? NCLT, National Company Law Tribunal. Regulation of future conduct of the company. It regulates the company's future operations to prevent recurrence of issue. The issue should not occur once again. Purchase of shares by a member. Share by a member. Change in directors. Removing oppressive directors. Managers or managing directors. Appointing new ones to enable recovery of undue benefits. Termination of contracts. Termination of contracts. Cancelling or terminating unfair agreements made with the directors, managers or other individuals. Fifth is transfer of property, cancelling fraudulent or improper transfer of the company's property. Sixth is imposing costs, ordering parties to bear the costs related to the proceedings. And seven, the last major power is winding up of the company, ordering the winding of the company if it is just and equitable. But a winding up due to operation becomes unfairly biased against the members. Friends, this is all for today. I will continue this in my next video. Thanks for watching.